Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Hey, just dropping in to say we're now on Patreon. If you want to support the project, head on over to patreon.com/legallistening, where you can unlock some fun bonus content with me, Zach, and some special guests. Thanks so much for all your support. Hey there, just me. I'm about to bring you the dissenting opinion of Justice Brown in The Queen and Goldfinch. If you want to hear what me and Zach thought about the case or hear a bit of context, head on over to the majority decision. It's a couple episodes ago. Enjoy! The following are the reasons delivered by Justice Brown. Part 1. Introduction. Patrick Goldfinch appeals, as of right, from the decision of a majority of the Court of Appeal of Alberta setting aside his acquittals and ordering a new trial. The issue to be decided is whether the trial judge committed reversible error in admitting evidence under Section 276 of the Criminal Code that the complainant and the appellant were friends with benefits. Before the jury, the complainant testified that she was sexually assaulted after the appellant would not take no for an answer. Her evidence was that she called the appellant to come over to his residence. After watching television together with the appellant's roommate, she and the appellant went downstairs to his living quarters. She told him that nothing was going to happen, meaning there would be no sexual activity. After she did not join him in his bedroom, he got angry, dragged her into the bedroom, pushed her into the bed, hit her face, and had sex with her while she repeatedly told him to stop. The appellant, on the other hand, testified that the complainant had called him to ask if she could come over because he owed her birthday sex. He picked her up and they drove back to his residence where they watched television and drank beer with his roommate. At some point, the appellant mouthed to her, quote, "I'm going to fuck you," after which the two walked downstairs together to his living quarters. He eventually followed her into his bedroom, where she got undressed before he did. They discussed which side of the bed she would sleep on to avoid hot flashes that happen when she sleeps on one particular side of his bed. They had sex and fell asleep. He woke to find her angry at him for hitting her in the face sometime while he was asleep. He became annoyed and told her to leave. In closing submissions to the jury, the appellant emphasized 11 aspects of the complainant's evidence that, in his view, exposed inconsistencies in her testimony sufficient to raise a reasonable doubt. None of these submissions referred to the relationship. Rather, it was the Crown that relied on the relationship. Its theory was that because they were in a sexual relationship, Mr. Goldfinch was expecting sex from the complainant that day. That's the only reason he went to pick her up. When he found out that he was not going to get it, he snapped. The trial judge would twice instruct the jury that the relationship provided context for how the appellant and the complainant knew each other, but it could not be used to infer that, because they were in a relationship, the complainant was more likely to consent on this occasion, or that the complainant's account was less believable overall. The jury returned a verdict of not guilty. I have read carefully the reasons of the majority. I agree that this appeal turns on how to balance the admissibility of evidence of a relationship that may be a necessary link in making full answer and defense with ensuring triers of fact do not use the existence of a relationship to engage in prohibited reasoning. And while I agree with much of the majority's overview of Section 276 of the Criminal Code, we disagree on its application to this evidentiary record. The majority reasons that the relationship was simply not relevant to any issue before the jury, and therefore engaged the prohibited line of reasoning that, because the complainant had consented to sex with Goldfinch in the past, in similar circumstances, it was more likely she had consented on the night in question. This appeal therefore presents 3 issues. 1. Does the ordinary meaning of friends with benefits invariably lead the trier of fact to engage in reasoning prohibited by Section 276 sub 1? 2. Was the nature of their relationship relevant to any issue before the jury under Section 276 sub 2 sub b? And 3. Should a new trial be ordered in the event the trial judge erred? These are difficult questions that go to the heart of Section 276. My view is that the trial judge applied the correct legal principles in her evidentiary ruling. The majority sees it differently, describing the clear infection of the context laid out before the jury with twin myth reasoning, making the jury privy to particulars that it should not have known about. While the majority reasons that this must have been caused by an error in the evidentiary ruling before trial, as I see it, the responsibility for any infection during this trial lies not in the trial judge's ruling, but rather at the feet of the Crown, who must live with its choices. I would answer the legal questions as follows. First, I say that evidence of a friends with benefits relationship will, in certain cases, and without engaging in prohibited lines of reasoning, explain to a jury how two people know each other, consistent with how other relationships are presented to juries. I agree with the majority that relationship evidence, without proper scrutiny under Section 276 and sufficient limiting instructions, can trigger triers of fact to engage in prohibited lines of reasoning. But I do not accept the majority's solution to this problem, which would treat evidence of certain relationships, for example married, dating, or boyfriend-girlfriend, each of which might also suggest previous sexual activity, differently in the Section 276 analysis based on how the particular relationship's sexual features, real or imagined, are reasonably perceived. I prefer the trial judge's evidentiary ruling, which treated the relationship between the appellant and the complainant consistently with other relationships in society. The jury could be told about the existence and nature of the relationship, but could not be told about its particulars or the frequency of sexual relations. The jury was then instructed twice on the permissible use of the evidence, to provide context for how the appellant and the complainant knew each other, and its impermissible uses, to suggest that, because they were friends with benefits, the complainant was more likely to consent on this occasion, or was less worthy of belief overall. Secondly, the trial judge's evidentiary ruling was consistent with the proposition that the existence of a relationship between the complainant and the accused may be admitted as relevant, but strictly where its absence would leave the trier of fact with the distorted representation of the circumstances surrounding the incident. The trial judge concluded this was such a circumstance. When the majority disagrees and finds nothing in the appellant's evidence that rendered his narrative untenable or utterly improbable, absent reference to the relationship, it is hard to find fault in the trial judge's determination on this point when the Crown itself took a similar position. Specifically, that admitting evidence of the relationship was necessary to prevent distortion. The Crown's objection was merely to the form, rather than the substance, of the appellant's description of the relationship. I am not persuaded the trial judge committed an error in law sufficient to ground a Crown appeal from acquittal. This leads to my third point of departure from the majority. Ordering a new trial is unfair, given the following considerations. The Crown's theory of the case against the appellant drew directly from the sexual nature of this relationship. The infection to which the majority refers was largely as a result of a contravention by Crown counsel of the terms of the trial judge's evidentiary ruling. And a successful Crown appeal from acquittal on this record inevitably lowers the bar which the Crown must overcome to show that a legal error had a material bearing on the acquittal so as to secure a new trial. How, after all, can the admission of this evidence be said to have had a material bearing on the acquittals, when the Crown was relying on the selfsame evidence to prove its case? The Crown was perfectly content in this case to refer, rely, and ultimately weaponize the sexual past between the appellant and the complainant, until the jury returned a verdict of not guilty. Only then did the Crown on appeal take the position that the sexual nature of the relationship must have led the jury to engage in prohibited reasoning, and that, notwithstanding the Crown's reliance on the sexual nature of that relationship, the appellant should not have been able to answer it. This is fundamentally unfair. These are the points that divide us. The jury rendered its verdict after being properly instructed on how to do so. I would allow the appeal and restore the acquittals. Part 2. The Voir dire decision. Court of Queen's Bench of Alberta, January 23, 2017. Before the trial, the appellant applied under Section 276.1 of the Criminal Code to adduce evidence that he and the complainant were friends with benefits, in order to dispel any erroneous impression that the jury might be under that he had sexualized an otherwise platonic friendship, or to avoid misleading the jury into believing that they were complete strangers. The Crown objected, saying that friends with benefits would trigger prohibited twin myth reasoning in the jury. It did agree, however, that the jury would need some context to dispel the notion that the appellant and the complainant were strangers. To be clear, the Crown's objection was not to the injection of context or, more broadly, to relationship evidence that insinuates past sexual activity, but to the term friends with benefits. The Crown's solution was to tell the jury that they dated for 7 to 8 months, broke up, then reconnected, and that on occasion, the complainant would visit the appellant's residence late in the evening and leave the following morning. I stress that it was the Crown's position that it would not offend Section 276 or undermine the interests it is intended to protect for the jury to be told that the complainant would occasionally visit the appellant, a former boyfriend with whom she had reconnected, late in the evening, and that she would leave only the following morning. The trial judge considered the competing positions. She directly addressed the prejudice that could flow to the complainant if the jury drew certain prohibited inferences from the nature of the relationship. She queried defense counsel during the voir dire, quote, "What is the safeguard, then, to prevent one of the twin myths that because she consented to the friends with benefits relationship 1, 2, 10, 20 times before that, she was likely to have consented on this occasion? What is the protection if this evidence is permitted?" End quote. In her evidentiary ruling, the trial judge agreed that without some context for how the appellant and the complainant knew each other, the appellant could not make full answer and defense. Bearing in mind that his credibility would be the central issue at trial, the jury could not properly assess, or indeed might well misconceive, the plausibility of his version of events were it prevented from understanding how the appellant and the complainant knew each other, or were it to simply assume they were strangers because no party had raised the issue of how they knew each other. Admitting evidence of the relationship would be no different than admitting evidence that an accused and a complainant were married, dating, or boyfriend-girlfriend. The point being, the trial judge believed the jury ought to be told how they knew each other in order to avoid misinterpreting things the appellant said or did as having arisen out of the blue. As she viewed the matter, keeping the existence of the relationship from the jury would leave a level of artificiality in the appellant's evidence and would prevent him from being able to make full answer and defense. Following a thorough examination of the relevant factors under Section 276 sub 2 and sub 3, the trial judge chose to admit the friends with benefits evidence, rather than the Crown's proposed account of former lovers who had reconnected to have adult sleepovers. As the majority notes, the trial judge remained very much alive to how a reference to the relationship could be misused to engage in prohibited lines of reasoning in relation to the complainant and her evidence. And she could not have been clearer in directing to the parties that, while evidence could be led about the relationship between the appellant and the complainant, no evidence was to be led about the relationship's particulars, the specific sexual acts the complainant and the accused engaged in, or frequency, the number of times they had sexual relations after they ceased living together. And once again, when, on the morning of trial, Crown counsel sought clarification about the scope of the evidentiary ruling, the trial judge reiterated that no evidence was to be led about particulars or frequency of the relationship. All counsel acknowledged they understood. Part 3. The Trial. Court of Queen's Bench of Alberta, February 9, 2017. At trial, the complainant initially testified that at the time of the assault, she was just friends with the appellant, that at no time since their formal relationship ended were they anything more than friends, and that she and the appellant weren't speaking in the months leading up to the alleged assault. Almost immediately after that, however, and still in chief, she testified that she and the appellant previously had sex in his bedroom. Crown counsel asked whether this occurred while they used to date, and the complainant answered that it occurred after they had broken up. Crown counsel then went one step further, contrary to the trial judge's clear and repeated instructions, and asked whether they had sex on a single occasion or on various occasions after they had broken up, and when was the last time she had sex with the appellant. The complainant confirmed that they had had sex on various occasions after they ceased living together. In light of this evidence adduced from the complainant by the Crown, the trial judge at the conclusion of examination in chief notified counsel that following the complainant's testimony, she would provide a mid-trial limiting instruction to the jury, warning against impermissible uses of evidence that refers to the complainant's sexual activity. After canvassing the text of the proposed instruction with counsel, and following the complainant's evidence, the trial judge gave the following mid-trial instruction. The court, quote, "You have heard evidence that the complainant and Mr. Goldfinch dated and then briefly lived together. At some point after that relationship ended, the complainant and Mr. Goldfinch did on occasion get together and have sexual relations. This evidence provides you with some context for their relationship, but you must not use this evidence to help you decide that because the complainant and Mr. Goldfinch had sexual relations in the past, that the complainant is more likely to have consented to what Mr. Goldfinch is alleged to have done on May 29, 2014. And you must also not use that evidence to help you decide that because the complainant and Mr. Goldfinch had sexual relations in the past, that she is less believable or reliable as a witness in this case. All right? Thank you." End quote. I have already summarized the pertinent aspects of the appellant's evidence. In his closing submissions to the jury, the following pieces of evidence formed the central planks of his case. Mr. Hatch, quote, "I'm going to ask you to consider 11 important items, and I'm going to list them for you. And there may be other items that you find important as well, and obviously you will consider those. I would like you, though, to consider these 11 items carefully. Number 1, the phone in the bedroom. Secondly, wanting Mr. Goldfinch off the computer. Thirdly, the timing, and I'm going to comment more on each of these in a few minutes. The fourth item is the absence of any evidence of any injury to the complainant's genitals. Number 5, the glasses being undamaged. Number 6, the kiss. Number 7, phoning the cab. Number 8, being worried that he'd lost everything. Number 9, testimony that he may have been flaccid throughout. And number 10, extensive lack of recall. Lastly, number 11, all hell broke loose. There was yelling, it was loud, and I'm going to invite you to look closely at each of those items." End quote. In contrast, the Crown advanced the following theory to the jury. Crown, quote, "The Crown's submission is that Mr. Goldfinch was expecting sex from the complainant that day. That's the only reason he went to pick her up. When he found out that he was not going to get it, he snapped." End quote. The Crown elaborated on this theory at the outset of its closing submissions by telling the jury, Crown, quote, "In this case, you heard the complainant, a 54-year-old woman, tell you that she was sexually assaulted. She and Mr. Goldfinch dated for 7 or 8 months. They lived together. She ended the relationship. Her evidence on those points is uncontradicted. She told you that she called him. He picked her up. She was open to the possibility of having sex with him. When the offer was made to accompany Mr. Goldfinch downstairs, she knew what that really meant, and she made it clear that she would come downstairs but there would be no sex." End quote. In her final charge to the jury, the trial judge instructed, the court, quote, "Finally, I wish to talk to you about the evidence you heard of the prior sexual relationship between Mr. Goldfinch and the complainant. You heard some evidence that Mr. Goldfinch and the complainant had dated, briefly lived together, and continued to have sexual relations on occasion in 2014. This evidence provides you with some context for their relationship. You must not use this evidence, however, to help you decide or infer that because of the sexual nature of their relationship, the complainant is more likely to have consented to the sexual intercourse with Mr. Goldfinch on May 29, 2014. The fact that they had sexual relations in the past or the extent of their sexual relations is irrelevant to the issue of consent on this particular occasion. Our law requires that consent be given to sexual activity on each and every occasion. Further, you must not use the evidence of their relationship to help you decide or infer that the complainant is less believable or reliable as a witness in this case, but you may consider any contradictions in her evidence about the nature of their relationship in assessing credibility as you would with any witness." End quote. The jury returned a verdict of not guilty. Part 4. The Appeal. The Crown appealed, arguing the trial judge erred by allowing the jury to hear that the appellant and complainant were friends with benefits, because it was used to advance inferences that were prohibited under Section 276(1) of the Criminal Code. Specifically, that the complainant was more likely to consent to the sexual activity with the appellant, or that she was less worthy of belief overall. a majority at the Court of Appeal of Alberta agreed and ordered a new trial, with Appeal Justice Berger dissenting. The relationship evidence had no relevant purpose other than to engage in prohibited reasoning, and its admission ran afoul of Section 276, Sub 1. Part 5. Analysis. In order to appeal from an acquittal, the Crown must demonstrate that the trial judge erred on a point of law. The legal question before us is, therefore, whether the trial judge erred in law because some legal principle precludes the relationship evidence, namely friends with benefits evidence, from being admitted in these circumstances. Any alleged errors reduce to this. Either the trial judge erred, as the ordinary meaning of friends with benefits invariably leads the jury to engage in prohibited reasoning under Section 276 Sub 1, or she erred because the evidence that they were friends with benefits was simply not relevant to any issue at trial under Section 276 Sub 2 Sub B. With respect for those holding contrary views, no such errors are shown here. Subpart A. The trial judge did not err in permitting the evidence to filter through Section 276.1. Evidence that an accused and a complainant are in a friends with benefits relationship, without more, does not solely derive its relevance in a criminal trial from lines of reasoning prohibited by Section 276.1. But this is exactly what the majority finds. The obvious implication of friends with benefits is that the parties are in a relationship understandable only by reference to its sexual features. The evidence, then, is seen as denoting to the jury nothing more than a relationship categorized by, and only by, a repeated pattern of sexual activity. The allure of twin myth reasoning becomes irresistible. Respectfully, I do not share this starting purpose. While I agree that the jury could draw from prohibited lines of reasoning in these circumstances, the test for exclusion under Section 276 Sub 1 is not satisfied merely where a jury could draw such inferences. The risk that the jury might erroneously infer consent from evidence of the nature of a relationship is a realistic danger in all relationship evidence, which I note the majority does not categorically exclude under Section 276.1. Rather, the test for exclusion under Section 276 Sub 1 is whether the evidence solely derives its relevance from prohibited lines of reasoning. In other words, Section 276 Sub 1 categorically excludes evidence of other sexual activity where its relevance is premised on one or both of the twin myths. But that is only part of the inquiry. The analyses under Sections 276 Sub 1 and 276 Sub 2 are not isolated from each other. Rather, they apply together, since Section 276 Sub 2 creates a presumption of inadmissibility, making all evidence of the complainant's sexual history inadmissible, unless it is a. Of a sufficient specificity for the interests underlying Section 276 to be properly weighed, b. Relevant to an issue at trial that does not draw its relevance from a prohibited line of reasoning under Section 276.1, and c. Of significant probative value that is not substantially outweighed by its prejudicial effect. If the evidence cannot meet each of these statutory criteria under Section 276 Sub 2, it is inadmissible. In practice, therefore, the voir dire judge should determine whether the evidence is of specific instances of sexual activity, is relevant to an identifiable issue at trial that does not draw from prohibited lines of reasoning set out in Section 276 Sub 1, and has significant probative value that is not outweighed by substantial prejudice. To be clear, however, and to repeat, the test for exclusion under Section 276 Sub 1 is whether the evidence derives its relevance solely from twin myth reasoning. Section 276 Sub 1 does not operate to exclude evidence which merely engages twin myth reasoning. Were engagement the test for categorical exclusion under Section 276 Sub 1, it would risk exclusion of all relationship evidence, or at least all evidence of relationships which also involve sexual activity, since that too would conceivably engage twin myth reasoning. Rather, relationship evidence will typically be filtered via the inquiry contemplated by Section 276 Sub 2 Sub B, being whether, in this case, the relationship evidence is relevant to an identifiable issue at trial. The heart of the Crown's appeal is that friends with benefits is too sexual in its ordinary meaning, and therefore solely derives its relevance from prohibited lines of reasoning such that it is categorically excluded under Section 276, sub 1. But the Crown does not explain why evidence of the relationship which this term denotes is objectionable, while evidence of other relationships which regularly pass through the filter of Section 276, sub 1, and yet which might also suggest previous sexual activity, for example, married, dating, or boyfriend-girlfriend, or for that matter, the Crown's preferred relationship description in this case of former lovers who enjoy adult sleepovers, is not. The trial judge reasoned, entirely correctly in my view, that Canadian jurors understand that relationships come in many forms. And, in any event, she made the jury aware of the permissible purpose for which the evidence of this relationship was admitted, to explain how the appellant and the complainant knew each other, and of the impermissible inferences that they could not draw from its use in popular imagination. It follows that the foundation of the majority's test for admitting relationship evidence under Section 276, sub 1, is that some relationships have aspects which transcend sexual intimacy, while other relationships, which also involve sexual intimacy, can be understood only through the lens of that sexual activity. The majority reduces the relationship in this case to its most carnal features, and leaves it to trial judges, moving forward, to determine whether the sexual features, real or imagined, of the particular relationship term before them would likely be used to engage in prohibited lines of reasoning. But, and I say this respectfully, this posture is unprincipled and rests on assumptions about relationships that I do not share. At the risk of stating the obvious, even relationships that involve sexual activity, but which lack the expectation or even desire of a more formal relationship, such as marriage or common law partnership, can be about much more than sexual activity. At the very least, evidence of such relationships will give important context to the non-sexual interactions between the parties to the relationship, which may be, as it is here, necessary to making full answer and defense. The majority sweeps these concerns aside. Instead, we are left only with the undesirable effect of the majority's reasons, being their creation of legally significant distinctions in this area of law between the right kind of relationships with sexual aspects, i.e., monogamous and stable, and the wrong kind of relationships with sexual aspects, friends with benefits, i.e., casual or occasional. In the result, those who live outside the scope of relationships privileged by the majority, i.e., those who live in relationships which are neither monogamous nor quasi-marital, are sacrificed, so to speak, to majoritarian sexual morality. The majority may not find it troubling to privilege, in a way that goes to the heart of the ability to make full answer and defense, certain kinds of relationships over others, but I do, and I respectfully decline to follow my colleagues through this moral thicket. Further, the majority effectively reads out crucial parts of the common law from Seaboyer, governing how trial judges should approach defense evidence, and resurrects the approach to evidence, specifically of creating predetermined categories of admissibility, which this court rejected in Seaboyer. And finally, this approach downplays the text and purpose of statutory provisions like Section 276.4, which recognizes that evidence may be admissible for certain purposes, yet inadmissible for other purposes, and makes a limiting instruction mandatory when any evidence of other sexual activity is introduced, even if it only refers to other sexual activity indirectly or implicitly, to cure prejudice and to warn the jury of the impermissible uses of that evidence. Here, the evidentiary ruling was crystal clear. The jury could be told the basic fact that the appellant and the complainant were friends with benefits, but could not be told about any details, including the frequency of sexual activity. The jury was instructed twice on the permissible use of the evidence, to provide context for how the appellant and the complainant knew each other, and its impermissible uses, to suggest that, because they were friends with benefits, the complainant was more likely to consent on this occasion, or was less worthy of belief overall. I therefore cannot agree with the majority that the evidence should not have filtered through Section 276, sub 1. Subpart B. The trial judge did not err in her relevance determination under Section 276, sub 2, sub B. Turning to Section 276, sub 2, sub B, the majority finds nothing in the appellant's evidence which, absent the information that he and the complainant were friends with benefits, casts him in a particularly unfavorable light, or which would render his narrative untenable or utterly improbable. On this basis, the majority finds that the trial judge's determination that the nature of the relationship was relevant to the appellant's ability to make full answer and defense to constitute a reversible error. On this point, I cannot find fault with the principles relied on by the trial judge which led her to that conclusion. Section 276 sub 2's evidentiary filter recognizes the relevance of evidence of a relationship between the complainant and the accused, and therefore allows it to be admitted, but only where its absence would prevent the accused from making full answer and defense, by leaving the trier of fact with a distorted representation of the circumstances surrounding the incident. The trial judge concluded this was such a circumstance, and, I repeat, the Crown was substantially of the same view. Its objection was not to the admissibility of evidence of relationship, but to the label. Indeed, the Crown's position has remained consistent that the nature of the relationship is not in dispute, a former relationship, now a friendship, that from time to time involves sexual activity. Preventing distortion was necessary for the jury to assess the credibility of the appellant's evidence, which was the most relevant and material issue with which the jury would have had to grapple. Indeed, it went to what Justice Sabinka, albeit in dissent, once described as the most fundamental rule of the game, since it went to this accused's capacity to raise a reasonable doubt on the strength of his own evidence. It is difficult to conceive of evidence of greater probative value than evidence that is essential to an accused's ability to make full answer in defense. This is particularly so where, as here, the evidence of the complainant and the accused are diametrically opposed in every material aspect, leaving credibility the most important issue at trial. The majority gestures to these principles, but ultimately finds that this jury gained nothing of value by knowing the appellant and the complainant were in a relationship. It in no way assisted them as it weighed the plausibility of the appellant's account, as it could have only been used to advance impermissible lines of reasoning. I am afraid I see the matter quite differently. To deny the appellant the ability to point to his relationship would in these circumstances disable the jury from meaningfully performing its central function of finding facts and seeking out the truth. How else, for example, could the jury properly assess his explanation for why he went over to the complainant's residence to pick her up that evening? He owed her birthday sex? Or his mouthing unprompted at her, quote, "I'm going to fuck you," in the presence of his roommate? Or their bickering about which side of the bed she would sleep on to avoid hot flashes? Or his knowledge of her hot flashes? Or that the hot flashes occurred while she was on a certain side of his bed? To prohibit the appellant from explaining these statements, or this knowledge, by testifying that he was in a relationship with the complainant, is to force him to tell an incomplete story. A story which includes an account of the act, but no explanation for how he and the complainant got there, and why he said what he said, and why he did what he did. More particularly, without this evidence, his actions, including his words and gestures, will have appeared to have arisen out of nowhere, creating a completely misleading impression on the jury. His right to make full answer in defense would be reduced to painting a picture of himself as at best crude and reckless, or at worst predatory. Ultimately, the majority suggests that the trial judge would not have erred had she simply accepted the Crown's proposed language of former lovers who from time to time had adult sleepovers. But it is far from clear that this is an improvement over friends with benefits, and indeed, in my view, it would appear more likely to invite Puritan and speculative inferences. And, as Appeal Justice Berger noted in his dissent in the court below, the court's language would not have been necessarily accompanied by either of the two limiting instructions the trial judge gave at this trial. The jury's collective mind would truly be left to wander. Instead, the trial judge concluded that allowing the jury to hear about the existence of a relationship without hearing evidence about its particularities or frequency, prevented the appellant's evidence from being considered through a distorted lens, and ensured the appellant's right to make full answer and defense was preserved. I find nothing in the trial judge's relevance assessment that constitutes reversible error. Subpart C. A new trial is procedurally unfair and lowers the Graveline standard. My third point of departure relates to fairness. I observed that it was the Crown's cross-examination of the appellant which directly put the sexual nature of his relationship with the complainant at issue. And it was the Crown who suggested that he had sexually assaulted her because they hadn't had sex recently. And it was the Crown who suggested that they had a tumultuous relationship marked with many arguments and her being upset with him but returning to him eventually. The difference, however, is that the Crown leaned into the existence of the relationship in order to advance a theory that because they were in a sexual relationship, the jury should find that he expected sex and was angry when she refused. At the same time, however, the Crown insisted that the appellant be prohibited from rebutting that theory, if his evidence would in any way indirectly reveal to the jury that the complainant had engaged in the same sexual activity that the Crown pointed to in support of its own theory. This is, as I have already observed, fundamentally unfair. What also strikes me as fundamentally unfair is the majority's characterization of the effects of the evidentiary ruling, in particular because the evidentiary ruling would not have revealed any direct evidence of other sexual activity, had not the Crown chosen to pursue a line of questioning that directly contravened it. The ruling, it must be remembered, should have had the effect of only indirectly or incidentally revealing the complainant's other sexual activity, because no evidence could be elicited about the specific sexual acts the complainant and the accused engaged in, or the number of times they had sexual relations after they ceased living together. The Section 276 regime recognizes that differing degrees of prejudice will flow from certain types of sexual history evidence over others. A trial judge assesses the extent to which sexual history evidence will risk leading the jury in this case to draw prohibited inferences. This is a core feature of the discretion afforded to trial judges. The majority provides a helpful guide for trial judges on the exercise of discretion. Where a trial judge is concerned about the jury improperly speculating on past sexual activity, the trial judge should clearly explain to the jury that they will not hear any evidence about whether the relationship included a sexual aspect. The jury must be instructed that no means no, and that consent in the past in no way implies or assumes consent in the future. And if relationship evidence is admissible, it should be adduced through an agreed statement of facts to minimize the need for examination and cross-examination. And yet, each of these principles was observed by the trial judge in her evidentiary ruling, her conversations with counsel, her cautions to the jury, and her final instructions. It was the Crown's decision not to adduce this evidence through an agreed statement of facts, as suggested by the trial judge, and the Crown's later contravention of the evidentiary ruling, which had the effect of introducing otherwise inadmissible evidence before the jury, that caused the problems at trial with the majority now, remarkably, lays at the feet of the trial judge. This strikes me as wholly unacceptable basis for a successful Crown appeal from an acquittal. That Crown counsel's caution in seeking clarification of the ruling, which is to be commended, did not prevent a contravention of the same ruling is demonstrative of a problem of application arising from the delicate balancing mandated by Section 276. What is agreed to in advance can go off the rails when a witness takes the stand. The majority identifies this as such a case, but then resolves the problem of application in favor of the Crown. This is unfortunate because the trial judge's evidentiary ruling, as well as her numerous interventions in the trial, were faithful and not a departure from the principles articulated in Seaboyer and Darish. She applied the correct legal principles. Such relationship evidence will be relevant where the accused would otherwise be prevented from making full answer in defense, and the features of the evidence only indirectly or incidentally reveal the complainant's other sexual activity. In such a circumstance, full answer in defense cannot be achieved by confining accused persons to saying what happened and not allowing them to explain how or why or to produce any corroborating evidence. The significant probative value of such evidence would outweigh any prejudicial effect, particularly when accompanied, as it was here, by an appropriate limiting instruction. And the proper balance under Section 276 would be struck. Finally, the majority's approach relieves the Crown of its high burden of demonstrating that a legal error had a material bearing on the jury's verdict. While the majority reasons that the relationship evidence tendered in this case would have had a material bearing on the acquittals, this does not account for the fact that the relationship evidence was relied on by the Crown against the appellant. And again, it was the Crown, and not the appellant, who contravened the evidentiary ruling and explored both the details, the location of previous sexual activity, and the frequency of that sexual activity. As Appeal Justice Watt observed in The Queen and Luciano, quote, "It is a worthy reminder that the appeal of an Attorney General is from the acquittal, not the admissibility ruling that is said to constitute an error of law. What is required is a demonstration of a legal error in the admissibility ruling and a nexus between the legal error and the verdict rendered, an acquittal. The authorities teach that acquittals are not to be overturned lightly." End quote. Here, the Crown has not established a sufficient nexus between the legal error and the verdict rendered. Again, I ask, how can the admission of this evidence be said to have had a material bearing on the acquittals when the Crown was relying on the selfsame evidence to prove its case? The Graveline standard is not met on this record. I say respectfully, the majority's position undesirably waters down the Graveline standard in remitting this matter for a new trial. Part 6. Conclusion. Ultimately, I agree with the trial judge's chain of reasoning under Section 276. Making full answer and defense includes being allowed to tell a story that is complete and coherent by drawing from relevant evidence whose probative value outweighs its prejudicial effect. This cannot be achieved by confining accused persons to saying what happened and not allowing them to explain how or why or to produce any corroborating evidence. Recognizing this, the trial judge, in my view, deftly managed a circumstance made difficult not only by the subject matter of the evidence, but by the Crown having exceeded the scope of the evidentiary ruling in her examination of the complainant. Her decision to admit this highly probative evidence for the limited purpose of allowing jurors to assess the plausibility of the appellant's account of what happened was faithful to Seaboyer and to Section 276. And her careful instruction to the jury regarding that limited purpose was sufficient to address any prejudicial effect arising. Jurors are not morons, completely devoid of intelligence, but are conscientious, anxious to perform their duties, and would not be forgetful of instructions. This jury rendered its verdict, having been properly instructed on how to do so. I would allow the appeal and restore the acquittals.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.